Madam President, thank you so much. Colleagues, I rise to present Senate Constitutional Amendment 10. We're on the brink of a U.S. Supreme Court decision that we have every reason to believe will topple Roe v. Wade and erode the right to abortion that was secured nearly 50 years ago, altering reproductive freedom in America as we know it. In California, we cannot stand by as women and families are left vulnerable. Together with Speaker Rendon and so many of you, we've introduced SCA 10 to ensure that the fundamental right to choose to have an abortion and to use contraception is protected in California now and for generations to come. The Dobbs versus Jackson Women's Health Organization case, the leaked draft Supreme Court opinion, and the vitriolic debate that followed has proven how precarious our reproductive rights are. This moment has taught us that California needs to be prepared. Those who are determined to strip away our rights will not stop with this case, and neither can we. We have to make absolutely sure that the people of California have access to abortion and contraceptives, no matter who is in the position to affect our rights, from our courts and any future state elected officials to those sitting on the U.S. Supreme Court, in Congress, and in the White House. Abortion is health care, plain and simple. And like any medical decision, it's a discussion between the patient and their provider. These are deeply personal choices that should be grounded in scientific facts, not anyone's political agenda. I've seen firsthand what it means when people don't have that access. During my time providing clinic services at a women's health center, I met a distraught mother whose daughter died after an illegal abortion in another state. I talked with a woman in the Navy who had been incorrectly led to believe she could not safely deliver her baby because she had an STD, a sexually transmitted disease. She was scared, she was confused, and she was alone, and she was misinformed. We helped her understand all of her options, that she could deliver a healthy baby despite having an STD. And when she chose to do just that, the doctor who had seen her at the clinic delivered her baby months later. These stories have stayed at the forefront of my mind years after, because these are real people who've been impacted, real families, real lives. I respectfully ask you to consider passing SCA 10 today and let the voters decide on this critical issue.
Senator Hertzberg.
Thank you, Madam President and Madam Pro Tem. I rise in support of SCA 10 to our California State Constitution. We need this amendment, members, in my judgment, because the actions taken by the Supreme Court, as was indicated by the Pro Tem, are on the verge of dismantling a woman's right to choose. And I think it's important to point out the very glaring fallacy being put forth by those seeking to strip a woman's right to choose. The argument they make is that the United States Constitution contains no right of privacy. They say correctly I might add, that the words abortion itself never appears. And the suggestion is that because these specific words don't appear in our Constitution, the precedents regarding a woman's rights to choose can easily be cast aside and overturned. But here, ladies and gentlemen, is what they're not telling you. The right to privacy has been embedded in our constitutional precedent for nearly a century. It protects every one of us in ways so fundamental, we now take them for granted. And to surrender it would be the gravest mistakes. For example, as a parent, do you think you have the right to allow your child to learn a foreign language? Well, back in 1923, Nebraska didn't think so. The state, amid a wave of anti-immigrant xenophobia, made it against the law to teach German to your children before the 9th grade. What stopped them? The United States Supreme Court, citing the right of parents and teachers to decide such things for themselves. Who's Mike? Let's talk about birth control. Should the sheriff be allowed to search your bedroom for contraceptives? Anyone here today ready to let the government decide? The answer is no. You can thank the Supreme Court for your right to privacy. Anyone here today ready to let the government decide what books and magazines you can read? Until 1965, ladies and gentlemen, it was the law of the land. That's when the Supreme Court of the United States unanimously found a right of privacy fundamental to the concept of liberty contained in our Constitution. The case had nothing to do with abortion. It was about a couple's dirty movies found at the home of a suspected bookmaker. But the fundamental principle, ladies and gentlemen, the fundamental principle of keeping government out of the people's private lives is the very same one that protects a woman's right to choose. Here's how Justice Thurgood Marshall put it. If the First Amendment, ladies and gentlemen, means anything, it means that a state has no business telling a man sitting alone in his house what books he may read or what films he may watch. Our whole constitutional heritage rebels at the thought of giving the government the power to control men's minds. If the court was correct in keeping the government from trying to control the minds of men, surely the same protection must apply to the bodies of women. Today, these antiquated laws, struck down decades ago, sound ridiculous, medieval, even Orwellian. But they weren't thrown out simply by chance or by the march of progress. In every instance, they were set aside by the High Court's recognition that the true human liberty only exists when people are allowed to make their own decisions about their minds and about their bodies. I would argue, Madam Pro Tem and members, that a woman's right to choose is as fundamental as basic to our liberty as the right to read and study and live the life you want. They all rest on the same foundation. To destroy one is to threaten them all. We stand here today because those rights are in peril, and we must do all we can to protect them. I ask you to support SCA 10. Thank you very much.
Senator Gonzalez.
Thank you, Madam President, and I am pleased to rise as well in support of SCA 10 as a proud co-author, and I want to thank our Pro Tem for bringing this very bold piece of legislation forward. The leaked draft decision from the Supreme Court, I don't know about you colleagues, but it has invoked feelings of dread and despair for many of our constituents over the last few weeks, and it's also lit a fire of passion and activism that will not waver in the face of those who attempt to deny women and pregnant people their reproductive freedom. Since Roe v. Wade was decided nearly 50 years ago, we knew this day would come, has been mentioned, and now is the time that we must fight and ensure that our California protects our reproductive freedoms, continuing to do that. This important decision will ultimately impact the most vulnerable, and we've said this before. Black, Latino, Indigenous, people of color, those with low incomes, and even those living in rural areas will be harmed the most. As we know, abortion care is health care. We cannot and will not allow for that, not in California. A reproductive freedom state that represents many of these communities. And I want to thank again our Pro Tem, the Speaker of the Assembly, the Governor, for introducing this constitutional amendment to formally protect every Californian's right to access. For these reasons, we must pass SCA 10, and I respectfully ask for your aye vote.
Senator Skinner.
Thank you, Madam President and members. I stand as Vice Chair of the Women's Caucus and a co-author of SCA 10. With the leaked decision, the Supreme Court majority showed us their cards. It's clear evidence of the court's intention to overturn Roe v. Wade and deny Americans the right to abortion, a right that we have had for 50 years. And if and when the court takes that action, it would be the first time in U.S. history that the court would have taken away a right that it granted. Now, the text of the leaked decision, if you read it carefully, is based on undermining privacy. And privacy rights or privacy protections are the aspect of California's current constitution that give us now abortion protection or abortion rights in California. And if the court majority in their decision undermines privacy, then our existing constitutional text may not be strong enough. So by bringing us SCA 10, the Pro Tem is giving Californians the opportunity to ensure that no one in California can be denied either an abortion or contraception. And these are two rights that are important to and supported by the overwhelming majority of Californians across the state. So the Legislative Women's Caucus, in addition to supporting SCA 10, is leading with reproductive justice bills to ensure that California is a national beacon for reproductive freedom. The time is now to enshrine this right in our Constitution, and the Women's Caucus thanks the Pro Tem for leading on this issue. We are confident that the California voters will approve this amendment, and we strongly urge your aye vote.
Senator Leyva.
Thank you, Madam President. I stand as Connie Leyva, a 55-year-old woman who can't believe that we're still having this discussion. I think my question is, when will we ever trust women? When will we ever trust women to make their own decisions about their bodies? We don't tell men how they can use their bodies, when or where and what they can do with them. And I think that we also forget that it takes two to tango. A woman does not become pregnant simply because she hopes she can become pregnant. She has to have a partner, and yet there are never any consequences for the man who gets the woman pregnant. All the responsibility lies on the woman. If she chooses to have an abortion, that is her choice. Madam Pro Tem, I thank you for bringing this forward, because not only should a woman have the right to choose and have an abortion if she so wishes, birth control. It is shocking to me that there are people who say you can't have an abortion. Oh, but you know what? You also can't have birth control. I mean, my God, why don't we just tell women we want you in the kitchen, barefoot and pregnant? Because really, that's what this is about. It's about control, and it's making sure that women can't move ahead. Let's let women make their own decisions. I'm happy to be a co-author of SCA 10, and I hope you'll all join me in support.
Senator Melendez.
Thank you, Madam President. I would like to start by asking a question of the author, if I may.
Will you accept a question, madam?
Of course.
She will.
Thank you. So what I would like to know is, does this constitutional amendment place any restrictions on when a woman can get an abortion?
It is consistent with current California law, so what exists today is as it would be. It is between the doctor and the client, the patient.
Okay, so if I may, because in reading the bill, I don't see anywhere, I mean, it's 3 sentences, so I don't see anywhere in there where it states that it is in accordance with current law. It seems rather open-ended, so I'm trying to understand where in the bill it would be very clear, should this go to a court, that it is to coincide with current state law.
It's simply stated, abortion right to contraception. It doesn't change practice in California. That is between a doctor and the patient.
Oh, okay, thank you. And I anticipated that that was going to be the answer, but I appreciate the response to it. With respect and deference to the Pro Tem, she feels very strongly and passionately about this issue. I feel very strongly and passionately from the opposite viewpoint. So I will share with you my thoughts, and I was listening to the comments made and the suggestion that there is fear and dread across California, and I just don't understand why someone would say that, because if there's any fear and dread across the state of California for women, it's because perhaps people in this legislature have whipped them up into a frenzy of fear, because under no circumstances that I can possibly imagine is abortion going to be in peril in California, no matter what the Supreme Court decides. And oh, by the way, let's talk about the fact that the Supreme Court decision doesn't ban abortion. It puts it back on the states. I don't know under what circumstances anyone in this body would think that the very next day or in the very near future even, that California would then suddenly turn course and change its position on access to abortion in California. That's just not living in reality. I also will tell you that I don't think it makes a lot of sense or is necessarily appropriate to compare access to abortion with laws that have been passed relating to viewing pornographic material. That's just entirely different. And as a woman who's given birth to 5 children, I just find it insulting that anyone would suggest that somehow those two are in the same category. And I just, it's not a personal, attack. It's just my personal feelings. In addition, I noticed that we had our governor who said, I think his quote was something about we're not going to sit on the sidelines as a state. And yet, he is sitting on the sidelines, his body is sitting on the sidelines when it comes to other issues that affect nearly everyone in this state, like the price of gasoline, that's almost $7 a gallon. That's something that affects everybody, but on something like this, he doesn't want to sit on the sidelines. On something that affects so many Californians and businesses, not a peep. I think the priorities are a little misplaced here. I guess I'm not going to change anybody's minds in here. I recognize that, but I felt that the other side of the issue should be represented. I will leave you with the statement from Pope Pius, if I may read this.
You may.
Yes, thank you so much. He said, "Those who hold the reins of government should never forget that it is the duty of public authority, by appropriate laws and sanctions, to defend the lives of the innocent. And this all the more so, since those whose lives are endangered and assailed cannot defend themselves, among whom we must mention in the first place are infants hidden in their mother's womb. And if the public magistrates not only do not defend them, but by their laws and ordinances betray them to death at the hands of doctors or of others, let them remember that God is the judge and avenger of innocent blood, which cried from earth to heaven." I respectfully request a no vote.
Seeing no further discussion or debate, Senator Penn.
Thank you, Madam President, Senators. I rise in support of SCA 10. And as a physician, I know one of my colleagues already said it, but I'll say it again. Abortion is health care. If a woman chooses not to get an abortion, then they don't have to get an abortion. If they choose not to take birth control, they do not have to take birth control. If they choose to do so, they should be able to choose to do so. And this is a decision between a woman and their doctor when it comes to if it's a procedure like an abortion. So, people may have different religious beliefs, they may have different other beliefs, and it's up to them which beliefs they wish to follow. What we should not be doing is imposing those beliefs on others. And so California stands for people's rights. When we talk about innocent lives, let's talk about women's lives that are going to be endangered. And so certainly, yes, here in California, we need to set the standard that say that we care about people's lives. That's why we have one of the lower maternal mortality rates, or the lower infant mortality rates compared to some other states. That's what we should be standing for. This constitutional amendment is a declaration that we will continue to fight for the rights, and here in California, we will continue to stand for the rights of women, but actually of everyone in California against the tide. So again, I urge an aye vote on SCA 10. Thank you.
Any further discussion or debate? Seeing none, Madam Pro Tem, you may conclude.
Madam President, thank you. Colleagues, thank you. I actually do respect the rights and opinions of every individual in this room to do what they feel they need to do. I do. I have been on the front lines. I have worked in a clinic that provided a full range, whether it was contraception, whether it was abortion, whether it was access to information about adoption options, whether it was to get the right type of health care for prenatal care and care to deliver a healthy baby. That's what I've been engaged in. That's what I care about. I care about individuals having the right to make those decisions, however difficult they are. We can't stand in someone's shoes and know their lives and their stories and what they're up against. And I'm not going to pick one story here or one story there and say, you know, this is why a woman should have the right to choose, or an individual should have the right to choose with their family and their structure, whether that be their church, but definitely with their doctor, their healthcare provider. They should be able to make these decisions. I have yet to be with any individual who did not struggle with this decision, whatever the outcome was, whatever they ultimately decided. Generations of individuals have grown up thinking they have this right, and they have had this right to privacy, which was defined as the ability to select or choose to have an abortion or not. Sadly, if this ruling comes to fruition, as we think it will, the leaked opinion from the U.S. Supreme Court, the next day, roughly more than half of the states where individuals live are going to wake up without that right. They're going to wake up without the option to make that choice. And I care about that. California could find itself very well in that position too. I don't think so, but I want to make sure explicitly that the right to choose an abortion and to have access to contraception or not is explicitly there. We thought we had the right to privacy that included that, even before Roe versus Wade in the state of California. I think this is important. I think it's necessary. It's real. Just ask those individuals, those women are going to wake up the day after that Supreme Court decision and find out they don't have that right. In fact, many already don't, because the states that have enacted those laws that are on the books, those clinics are closing. Those healthcare providers are not able to provide healthcare to their patients, to their clients. Respectfully, we do not want that to happen in California. And yes, I know that women are already coming here to get services. They were before in states where there were more restrictive laws. That woman I talked about that lost her 17-year-old daughter, they lived in Indiana. So this is important. This is basic health care. Let's make sure Californians continue to have this right regardless of the courts, of elected officials, from whatever position we come or are. Let's make sure these rights are enshrined in our Constitution. Let's let the voters reaffirm that they believe in this right. I ask for your aye vote.